5016, Pima County Committee of the Arizona Libertarian Party et al., Pima County Treasurer and Pima County. Council, please name appearances for the record.
Ronna Fickbohm on behalf of Pima County, Your Honor.
John Richardson on behalf of the County Treasurer, Beth Ford.
Bill Bryson and Ralph Ellen Judge on behalf of the Libertarian Committee.
Good morning, everyone. Ms. Fickbohm, do you need a moment to catch your breath?
My ear bright red from being on the phone for 2 hours.
If we're all ready to proceed.
I'm ready, Your Honor. Thank you.
Mr. Reiser, this is your motion. Let me just ask a general question to see if we can narrow it. And that is specifically, what are you asking the court to do? I mean, is there a mechanism in place that you think the court can utilize?
Well, Judge, with my motion, I submitted an order, basically like 2 or 3 sentences.
You know, I saw that your notation that you had done so and looked for it with our paperwork and didn't see it.
It wasn't delivered with mine either.
Counsel, would you like to take a look at it?
I've seen it.
Is it the same one as you circulated separately? I didn't get one with your motion.
I didn't get one with the motion, but I assume it's the same.
Counsel, I'd just like to have you take a look at that and we'll see if that helps frame what we do or don't do this one.
Okay.
Will either be opposed or object to the language in that proposed form?
Yes.
Okay. Thank you. Then, let's go ahead and conduct the hearing. Mr. Reiser, you may begin.
Just a little, overview. What we're seeking in this case ultimately is for some prospective relief for future elections to protect purity of elections so that we'll have an accurate count and so they can cheat. So we have specific proposals so that the public can know and everybody can know that they didn't cheat, it was an honest count. What the Court of Appeals has said was that to get to that point, we need to show harm. And actually, we're coming at it from a couple directions. One is the system is so bad, and they can cheat anytime without getting caught, that we need these prospective relief in any event. But we get to show, and one way that we show that we need it is that they in fact cheated with the RTA. So the Beth Ford is in a position where really effectively she's out of everything in this case, because she went to court and Judge Harrington asked what her duties are. Harrington said the law requires you to destroy these ballots, and that's your only duty. But that's been stayed because of this counterclaim. So the question then is, since the contents of the ballot box are going to be and are key evidence in the case, how can those be protected with assurance? And it's a big problem, because I gave you an exhibit and the other motion to depose on Chuck Huckleberry years ago issued a press release that went out saying that he had ordered the county attorney and the election department to secure those ballots so that no one would have access to it. But that wasn't done, and Pima County argued, well, sure, that a press release and a whole memo on that, but it wasn't, didn't have Bill Reisner's name as the two-person on it, or the Libertarian Committee's name as the two-person, so we can ignore that. Beth Ford has claimed in the past that she had directed that the boxes be protected, but Iron Mountain's manager testified under oath that Pima County's a client and they've always had access. So we asked, I asked Beth Ford, how did you do this? How did you tell these people? And then I have a contract that's Your Honor has, that's part of the response from Beth Ford, and then and it all talks about how it's Pima County, and then it has to be in writing changes, and then somewhere at the very end, there's this little thing that says amendment to B 502460 blah blah, and that's supposed to be what protected it, but clearly that didn't happen. And then finally, and I submitted a copy of the disclosure statement, and I would call your attention to pages 64 to 66 that talked about what John Moffett did in this court, in this clerk's office. And this is just stunning. And I'm certain there's no dispute about any of this since it's all videotaped. We had an incredible meeting where we're over at the Board of Supervisors conference. News cameras, everybody's there. It's a big deal where the county, during the database lawsuit, is we have two hard drives. One identical, one that the county owns, one that the Democratic Party owns. With great ceremony, they're put in a box with seals, everything up. Taped to the top was a thing saying, only when both are present can this be opened. We couldn't touch it. Again, videotape, the sheriff has to walk it over, personally handing it to the clerk. This goes in the vault. Here it is in the vault. They showed us where it was in the vault. And then John Moffett walked in, walked out with it, not so much as signing his name. There was not a piece of paper there that said how he got it out. And while it's in his office, next to Chuck Huckleberry's, while they're working on a program to see if the data would show they cheated, we're exchanging emails about how and when we would both go together when he's already got it. It is stunning what they did. And so what Beth Ford is suggesting here is that we not have a simple order directed to Iron Mountain that says only when the court orders it can anybody get to it, but that she send a letter on her stationery telling them that that the court should do this and that she has a complicated several pages where if somebody wants to get in the ballot box, they write her, and after a few days they go to the judge and they do that, and then she sends a copy of this thing to Iron Mountain and so forth. I think it needs to be simple and direct. Iron Mountain needs to understand that only through a court order can anybody access those boxes.
And when you say those boxes, are you talking about those boxes numbering from 353-469-002 through 353 inclusive of 353-469-106?
Exactly. The Iron Mountain has an inventory system. Those boxes have been identified as the boxes that contain the ballots or whatever's in them. you know, frankly, we have reason to believe the boxes have been stuffed, and those aren't necessarily the original ballots. But whatever's in them needs to be protected in this lawsuit, and it needs to be a direct order, and we certainly can't trust Pima County, and it needs, the games in terms of that sort of stuff need to stop as best as we can. It's hard to have faith really in any storage in view of what Pima County did to the vault of this court. That is out of my comprehension, that someone could simply walk in and walk out, but they did it, and that was really a demonstration of incredible authority and power within the system, demonstration of who's in control, and phenomenal. But we need something simple and direct, and that's why I'm suggesting that my 2 sentences work a whole lot better, because it needs to be simple and understood. There's only one thing. You're ordered that only if you got a court order can somebody, anybody, get to those boxes.
By get to those, do you mean open them? And I'm not trying to be coy, but I'm just trying to understand. I assume that's what you mean, that they cannot be opened.
Well, I suppose that's true, but the process, as I understand it, from Iron Mountain, is that they have a storage facility. You come in and you say, I want these boxes, and they fetch them and bring them to you. So it's not only opened, it's fetched as well.
All right, thank you. Which respond first, or Ms. Fickbohm?
I agree that Beth Ford is about ready to take a limited role in this action, but I do want to clarify that she will always have a continuing interest in the issue that started this litigation. Beth Ford commenced this litigation to get an order from the court telling her when it would be appropriate to shred the ballots from the 2006 election. She'll still eventually need that order. It's still in this action that order will emanate, but we don't anticipate that order is going to be issued until the dispute about alleged improprieties in the election gets litigated, and Beth Ford has no interest in that particular, in that battle. She only has an interest in issues that relate to access to the ballots and eventual destruction of the ballots. The Libertarian Party and Mr. Reisner by letter have confirmed in writing that Beth Ford was not involved in any of the alleged improprieties, that they do not seek any relief from Beth Ford. So at the end of the last hearing, the court said, this court said, why don't you go out and see if you can put together a stipulation so we don't have to do this by motion. I agreed I told the parties, I agreed to do so right after I did. I put something together and submitted it to the parties. Mr. Reisner does not like the proposal that we've made, but we think ours is the better proposal for the reasons that I'll explain. You know, Beth Ford is not particularly troubled by a court order, but one, she doesn't want a court order suggesting that she has done something wrong in the past, and I think when it says for good cause of hearing, I'm going to order the following, suggests that, and we think that that would be inappropriate. Whether Mr. Mofford went into Pima County Superior Court Clerk's office and took something, I don't know anything about that, and I don't have any reason to dispute it, but it has nothing to do with whether when these ballots were in Beth Ford's possession, they had any sort of problem. No evidence of any sort of problem in that regard has surfaced. The contract, although it says kind of county throughout it, when it talks about the Exhibit A to the contract, it talks about these materials. The customer is labeled as the Pima County Treasurer's Office. She did follow it up with that specific specific, and she wanted to get very specific because she knew this fight was occurring in 2008 with a subsequent thing saying, hey, I want it in writing on my letterhead. And Beth Ford tells me at that time she asked Iron Mountain, anybody access these other than the times when the court has been involved? And they said no, but you know, I'm sure we're going to find out. They're going to take the Iron Mountain deposition in a month. She has no information to suggest that the ballots have been accessed other than the 3 times when judicial process has issued. And that's how many times that has occurred for these ballots. I think, so the first problem with the order proposed by Mr. Reisner is that it suggests there's some sort of good cause existing right now, and we don't think that exists. The second problem we have with it is you're issuing an order against a non-party, and we think that's problematic. Somebody who has had no notice, no opportunity to say anything with respect to it, and I don't know that, I think it's not a good practice to have orders issued against reasonable processes to inform them and copy them to all the orders and say, hey, you have to follow this. And you know, if they're going to violate what would occur as a result of you issuing the order against us, and we're conveying it, we give her a copy to you, this court's order and stipulation, everything, ignore your order too, because I don't think there's any jurisdiction for the order. So we think the appropriate thing, if a court order is deemed necessary, we think the form of the type that we have proposed, where it involves parties and good, and I don't believe complex procedures, is the proper way to go. Thank you.
Your Honor, I'm not going to repeat everything that I already put in my opposition. I understand that you carefully review everything that the parties submit. I would like to clarify the record in a few regards. Number one, Pima County has no desire to access these records. Number two, Mr. Reisner's client's reply says that Pima County and Beth Ford have opposed all his client's efforts to find out what the Iron Mountain records really show. I gotta tell you, that is absolutely untrue, and you'll notice that he didn't attach any fact sources to prove that it's true, and whenever I get irritated at seeing his being a court historian, which occurs over and over again, I have to continually remind myself, well, we all know that what the lawyers say isn't evidence, and what Mr. Reisner is saying to you isn't evidence, but I just want to be clear on the record that, in fact, I've suggested informally, you know, why doesn't somebody just ask Iron Mountain what the records show, and then you can see that nobody's accessed the records and this is all about nothing. Pima County has never said, we object to you simply asking Beth Ford to go get a certified statement from Iron Mountain listing who's accessed the records since the day they came to them and show it to you. It can even not be from her. You know, he doesn't really want that. That isn't really what this is about. The next thing I want to make clear is that in his reply, his client says that Pima County doesn't deny that Beth Ford failed to protect these records. That is also untrue. My understanding from the get-go has been that everybody thinks that Beth Ford has taken her obligations under Title 16 that are imposed under penalty of criminal prosecution very seriously, which is why she filed this action in the first place. I'm not really going to spend a lot of time responding to Mr. Reisner's passionate arguments about cheating and cheating with the RTA election, because that really is separate and apart from the issue of whether there is good cause for you to issue an order requiring Iron Mountain to do that which Beth Ford is already charged with doing by statute. But I just want to be clear on the record that Pima County denies that whole cheating, blah, blah, blah theory that Mr. Reisner keeps spouting in support of motions that it doesn't even have anything to do with. And then we have Mr. Huckleberry's memo, which Mr. Reisner is now calling a press release. He has given it to you. You can see it's directed within the office to the head of the elections division. It wasn't a press release. It wasn't directed to Mr. Reisner. Somehow Mr. Reisner got a hold of it. That doesn't really matter. There's nothing in it that's a big secret. But it's absolutely untrue when Mr. Reisner says that what Mr. Huckleberry wanted to see done wasn't done, because you've got Beth Ford's attorney here telling you that in fact Beth Ford took those steps to do what was necessary to make sure that the records were protected. Then Mr. Reisner refers to this whole story about John Moffat. As with Mr. Richardson, I wasn't involved in that litigation. That's the database litigation that was in front of Judge Miller. The first thing I want to do is once again go back to, you just heard a lot of facts about that. They all came from Mr. Reisner. What the lawyers say isn't evidence. What he's referring you to as evidence is a disclosure statement signed by him. Once again, this is nothing more than Mr. Reisner's personal theory. And the other thing I'd like to say about that is, and Mr. Reisner continually brings that up, you know, obviously because it makes good film footage. If he really thought that John Moffat or anyone else had acted in violation of what Judge Miller had done, the action to address that in connection with is Judge Miller's action, not to come in, you know, one or two litigations later and say to you, well, they did something wrong in connection with Judge Miller's action, so now you should be doing something even if there isn't good cause for it. Beth Ford, after we were last in front of you, her attorney did approach Mr. Reisner and I with a proposed order to allow us to avoid this hearing today, Your Honor. And they asked me if the order was okay with my client. And my response was, I don't think the order's necessary, but I'm not looking to spend taxpayer dollars on a hearing. I'm not going to agree with Bill Reisner's proposed order because it says that good cause exists, and that's absolutely false. But as a compromise, this is acceptable. Mr. Reisner doesn't want any order other than one that says good cause exists. And I would just suggest to you, Judge, that if an order was really required, this action has been pending for 3.5 years. We've had a presidential election in the interim. If this was really so urgent and so necessary, they would have brought it up a long time ago. What this is really about, Judge, is the creation of new film footage for their commercial enterprise. If you go online and Google fatally-flawed-the-movie.com, you will see a documentary that Mr. Brakey, who asked you to film today, put together starring Mr. Reisner, that was commercially available over the internet for $20 a pop, and in fact I think he even screened at the Loft, and you know, congratulations to them for putting forth a documentary that got that kind of attention. But this wanting an order finding good cause, this refusing to agree to a reasonable compromise suggested by Beth Ford so that we could be here in front of you today with the cameras rolling, in my opinion is really all about creating more film footage and not about there being good cause for issuance of the order. And I know that there's the what's the harm if I issue the order, and the harm is that it implies there's good cause for issuance of this order, which frankly is insulting to Beth Ford because it implies she hasn't taken her statutory duties seriously and isn't doing what she's charged with by law, and it also implies that you to some extent have accepted his theory that Pima County has gone in and meddled with those records, and that's just simply false. Thank you.
Thank you, Mr. Reisner, your report?
Yes, Judge. At the last hearing, where we were talking about deposing Iron Mountain, and Ronna Fickbohm was arguing, Pima County was arguing that against that request. Her argument talked about how in front of Judge Bork, she was successfully able, on behalf of Pima County, to prevent us from obtaining information that of what happened to the, what had happened to those boxes. Today, same week, today she comes in and says, well, it's not true that what Reisner says, that Pima County has ever opposed efforts to find out what happened at Iron Mountain. Getting to the, just hate to divert attention with such things, but it's fine. phenomenal that in the same week we get both sides of that. The good cause is that it's important evidence that needs to be protected. That's the good cause. Beyond that, we certainly have, and she did not, you know, it's funny, she talked about the documentary Fatally Flawed, which hopefully she's seen, which has footage of John Moffat walking into the office with the clerk's office, footage of the clerk saying it's not here, we don't know how it got out, footage of people walking it, you know, the sheriff taking it into the clerk, all of that's, she's not, and yet she talks about this documentary. She doesn't deny that Moffat did it, but says, gee, you know, this is a disclosure statement, and it's not evidence. But I'm not asking you to hold him in contempt, but it is stunning what was done with this court's vault, which simply heightens the need for it to be clear to Iron Mountain. And I think a clear order from this court to the bailee of these key evidence is much better than a complicated order that relies on forward communication and telling them what to do. And they repeatedly say, gee, Ford's done this really great job. But if she did a great job, how could Iron Mountain have said no one ever told us? Iron Mountain, you have in front of you the sworn testimony that says that that Pima County's always had the ability to go in and get to those boxes. So clearly she didn't protect it. Clearly what Huckleberry had said and asked the county attorney to do, they didn't do. So if the county didn't do it and the county attorney didn't do it and Beth Ford didn't do it successfully, the court is where we are. This is evidence for a court proceeding, and we want the court to send a simple, direct order. Thank you.
Mr. Richardson had asked, or proposed, I should have asked the question, how can the court issue an order that controls a non-party? How can the court issue an order over a non-party to the case? In your argument there in closing, you mentioned the word bailee. Is that how you think that legal authority is created? The existence of that contract and or a bailment that was created? That's one of my concerns. To be very candid with you, counsel, and that is if I have the authority to issue an order that controls someone who's not a party to this action. Can you address that?
Yeah, why not? I mean, don't you do it? Doesn't the court do that a lot? Don't you issue orders for people to show up in court, orders for you to bring evidence, orders for you to do this, orders to do something else? The court's not powerless to order people who aren't specifically a party in front of them. I mean, I don't see what the problem is. So.
Okay. All right. I'm mindful that I have one matter under advisement. What I'd like to do is take this one under advisement as well and issue a ruling that encompasses both of those issues and get it out to you fairly quickly. So I will tell you that I have a trial going away next week, so my hope and plan is that I can get you a ruling by noon Wednesday, if not sooner. So you can expect it in that time frame, if not sooner. Anything else, counselors?